Hello, this is Alexander Cross with Law Offices of Cross and Associates. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of sexual molestation by his wife's daughter. Criminal attorney Morgan Hill, accused of sexual molestation, Morgan Hill. Sexual molestation, Morgan Hill. I'm accused of sexual harassment by my partner's daughter of 13. She tries to seduce me when she comes out of the bathroom semi-naked. Well, I need to know exactly what type of touching. Are we talking about just touching? Are we talking about, is it verbal, oral? Is there oral sex involved? Sex? It makes a huge difference. Now, if we're talking about touching somebody who is 13, under the age of 14, that would be a violation of Penal Code Section 288, parentheses A. That's a felony that carries up to 8 years state prison, plus having to register as a sex offender for life. Obviously, if you are being accused of having sex with a minor, there will be a sexual penetration charge. And of course, if there's any other kind of sexual behavior, you'll be charged with that as well. All of these carry lifetime sex registration. Now, a big part of the evidence here is going to be whether or not there are text messages between you and the alleged victim. 13-year-olds, a lot of times, they have cell phones, and sometimes there are messages, phone calls between you and the alleged victim. If there are no text messages, or if there are text messages but it's clearly sort of like a stepfather-stepdaughter relationship, that would help tremendously. Obviously, if there are text messages indicating that there's something else going on, that's not going to bode so well for you. You have to be very, very careful, because very soon, if it hasn't happened yet, very soon, you'll be subject to something called a pretext telephone call. In a pretext telephone call, the alleged victim will be with the police, and she will be in contact with you to try to get you to make an incriminatory statement. She'll ask you something like, why did you touch me? Or why did you do this? Why did you do that? And if you basically don't say anything, if you don't say, what are you talking about? Hey, leave me alone. This is ridiculous. Why are you making stuff up? If what you're saying is not that, it's not going to bode well for you. So you get a phone call from this alleged victim, you might want to just block her number. It'd be the best way to go and contact an attorney. Now, here's the other issue. If the police get a hold of you and they want to ask you questions, please, please, please never respond to those questions. Remember your Miranda rights. You have the right to remain silent. Everything you say or do will be used against you in court. If you have the right to an attorney. If you can't afford an attorney, you'll be provided with a public defender. So, really in these situations, you really need to remain silent. You don't want to say anything incriminatory, and really need to speak to an attorney so that your attorney can go to court, enter pleas of not guilty, order copies of all the evidence. The judge will have to give you a new court date to come back and start discussing the matter with the DA's office. It is possible that a private investigator may have to be contacted or contracted in order to speak to the victim and witnesses to see if there are any incriminatory or actually inconsistent statements. Regardless, if you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime here in the San Francisco Bay Area, call us at 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got a DUI and driving without a license. Criminal attorney Morgan Hill. Accused of sexual molestation, Morgan Hill. Accused of sex crime, Morgan Hill.